The following program is made possible in part by the Dayton Bar Association.
Again to You and the Law. This presentation is for March 2022. My name is Jeff Swillinger. I'm your host. I welcome you, and I am very happy to tell you that our guest this evening is attorney and CPA Christopher Cowan. Those who have viewed the show in the past might be very familiar with Chris. He's been a stalwart supporter of the show and a guest of ours for many years. Tonight, this program is going to be a little bit different. Chris has often spoken and focused on taxes at various levels of government, but tonight we're going to spend a kind of a primer on probate law and estate planning. Chris, I would like to tell you folks, has been practicing many years in the Dayton area, doing work, as I said, as an attorney and as a CPA. His firm is called Cowan and Hilgeman. They're located in the downtown area, and during the show, you'll see his phone number come across the screen. I will give it to you. It is 937-222-2030. And his address is 12 West Monument Avenue, Suite 100, Dayton, Ohio. In addition, I'd like to remind you, as you already heard this evening, this program is underwritten by the Dayton Bar Association. The number at the Dayton Bar Association will also appear on the screen, 937-222-7902. And particularly, if you get a chance, we'll talk a little bit about the lawyer referral service for those of you who may not have an attorney and may be seeking some further advice and follow-up relative to issues we've discussed this evening or in past shows. So without spending too much other time here with introductions, I will just merely say, I hope you're watching us live on DATV. We also are live streaming tonight, and you will be able to watch the show on YouTube, on DATV's YouTube station. Within a day or two, it'll be on YouTube. Past shows are on YouTube. And we hope that if you have questions during the course of the show this evening, that you'll call in. Your questions will be taken, since the show is on Zoom, your questions will be taken by the staff and they'll be briefly summarized for me, and I'll see it on my screen. And then we will, at that point, try to stop what we're talking about and try and answer your question if we can. The show again is 937-223-5311, and that's the number again you'd call with your questions. So I'm sorry for any technical difficulties that we might have had getting started here tonight. I'm sure they were at my end and not the work of the folks at the station, who do a tremendous job putting this show together and making it work. So without further ado, Chris, again, welcome, and good to see you again, my friend. And let's talk about estate planning and give an update on that topic tonight, and see where we can take it. Let me just jump right in. Let's suppose we're talking about estate planning, and let's take a couple, maybe a young couple, maybe with children, without children. They are talking about doing some estate planning. Maybe it's just one individual who's talking about doing some estate planning. Let's say they're somewhere in the age range of 25 to 35 years old. And they come to you and they say, either I work, or my partner and I, my spouse and I, we work, we want to do some estate planning. Can we do this if we're doing it as individuals? Can we do this as married individuals? Can we do this as unmarried individuals? Um, what approach might you take with them? What kinds of questions would you ask them to get started? And let's talk about the different vehicles for delivering that estate planning. We'll be talking about financial powers of attorney, healthcare directives, living wills, of course, a last will and testament, and also something called a revocable trust. So, Chris, with that, why don't we jump right in and let's pretend with someone sitting across from your desk, however you want to set the stage for one or more people with whom you're speaking, and what questions might you have and how can you help them?
Jeffrey,
Yes, sir.
it's good seeing you, my friend. I haven't
Thanks.
seen you for a while. I wish Jeff, I wish we were in the studio doing this, but you
Yes,
look great.
Thank
And thank you for that very generous and warm greeting. It's good. And yeah, what we can talk about are maybe even, I can even boil it down a little clearer or faster or a little more concise. Jeffrey, in Ohio, everybody over 18 years old should have at least 4 things. They should have a financial power of attorney, they should have a medical directive, they should have a living will, and they should have a will. So what does what here? First of all, what we're talking about is people who are unable to make a medical or a financial decision while they're alive, and they have some sort of either physical or mental impairment where they cannot bank, they cannot communicate with a physician, they cannot talk to a health professional. They are in a position, either physically or mentally, where they cannot make informed decisions for themselves. So just picture either me or you, we're going through our lives every day, we're driving cars, we're doing stuff, we're going to the bank, we're dealing with children, we're dealing with spouses. But we all know things happen to people in their life. It happens when they're young, it happens when they're middle age, it often happens later in life because they're older and things start breaking down later in life. So you aren't able to bank if you're not mentally clear. The physicians at any of our hospitals are not going to be comfortable discussing your medical conditions to you if either you can't talk to them or you're not making clear decisions. And so the first 3 things, the financial power of attorney, living will, and medical directive, we're talking about an agency relationship. And this is critical because what we're talking about is somebody stepping in your shoes. If you have either a physical or mental impairment where you cannot make financial decisions, let's talk about those first. You can't make financial decisions, you can't write checks, you can't figure out how to pay your real estate taxes or Dayton Power and Light. Who's going to do those things for you? And I get it. People have trouble, especially young, healthy people. People like you mentioned in their 20s and 40s, they're out there doing a million things. They think they're invisible. They really don't think they're going to have a problem with a mental or a physical problem. But these things happen. And what we're getting to is somebody stepping in somebody's shoes and making those decisions for them when they cannot make them. So you're making a decision to have somebody help you downstream when you cannot help yourself. Now, in your fact pattern where you talk about a mom and a dad and a couple of kids, normally what we see, in a happy marriage, when we have a nice harmonious family, we're often going to see mom will be the agent for dad, dad will be the financial agent for mom. And if the kids are minors, they can't be backups. But a mom, a dad, a brother, a sister, somebody from church, somebody in the neighborhood, That could be somebody who could be a backup under the financial power of attorney. So the financial power of attorney is sort of like a little safety net. It's a safety net when you can't make the decisions for yourself. You'll have somebody make those decisions. So why would we want to do this? Why would somebody even go to the bother of seeing an attorney, discussing all this stuff? Sort of unpleasant for a lot of people. We're talking about things going wrong, bad problems physically, bad problems mentally. What we're trying to avoid is we're trying to avoid Ohio guardianship. And that is a whole safety net that's already provided by the government because people don't have agencies. They don't have people appointed to handle their affairs for them when they're not able to handle them. And so we have a whole system of the Ohio guardianship. It can be either for the estate or the person or both. And we can have different people appointed by the judge to handle these affairs. But somebody who would say, for example, Jeff, be in a car wreck. They're in a car wreck and they're working, they have children. They have none of these documents, no agency documents at all. I know that moms sign dad's paychecks and they'll do things with the credit card, and there'll be people out there sort of edge cutting on different sort of things, and there might be some winking by somebody at the hospital. But when push comes to shove, I mean, if you really need to go to a real estate closing and sign a deed, a spouse just can't walk into a closing and just sign a deed for somebody who's married to them. Title agent isn't going to go for that. An income tax return isn't really supposed to be signed by a spouse for somebody, for another person. Things like health decisions, you really aren't supposed to be barging in on somebody who's in a hospital and telling that person what you want done for somebody else. So eventually, if the impairment, the physical or mental impairment, runs for a long period of time, somebody's going to say, well, if you don't have agency documents, we need something from the probate court. And that gets us into the guardianship. And so to get a guardianship, you need a doctor. A doctor has to say, if it's me who's impaired, that something has happened to Chris, and he's not able to make health and or financial decisions. The person who is the applicant needs to be a resident of the state of Ohio. They need to get bonded. There would be a hearing at the probate court, and our probate judge would make a determination. Is that person competent or not competent? Is a guardian necessary? If the guardian's necessary, the bond's accepted. You have to file an inventory. There's a budget. Our court, and we're in Montgomery County, but we have 88 counties. The courts are all the same. They're not going to let you just spend off somebody's money unless there's a budget set up, an inventory's filed. And then if the person stays impaired, the court's going to want an accounting at least once a year about what money came into the guardianship, what money came out of the guardianship. Are the assets still on hand? Are they insured? Is the bond sufficient? And you end up into a court supervised management of somebody's affairs on a personal level and on a financial level that really continues until one of two things happen. Either the person gets better, their health improves, their mental clarity improves, or we wait until somebody passes away. There really is no other alternative once you're under a probate guardianship. Either the ward will die or the ward will get better. I have seen wards get better, but that is not the common fact pattern. The more common fact pattern is somebody will pass away. So what we're doing here is we're spending a little time, and Ohio law permits, and some of this stuff is relatively new, like the living will was not statutorily adopted in Ohio until 1991. So that's relatively new in the legal world. So all through the 80s, people asked me about living wills. Practitioners were putting together sort of proposed or suggested, or here's a document I think might work, but there was no statutory authority in Ohio for an official living will. Well, now we have it. and end of life decisions then, and often people who are near end of life aren't clear. And so now this allows somebody to name an agent, and they can discuss end of life decisions with the healthcare providers. And the theory being that the agent knows what the principal wants to have done for him or her when they're at that kind of a period in life. And you get somebody to make a decision for somebody who can't make that decision. So that would be sort of a rough sort of explanation of the financial power of attorney, which is only dollars and cents, the healthcare directive, which is basically non-life and death decisions, and the living will, which is end of life medical decisions for somebody who can't make those decisions.
There's something that winds their way through all of this, and you touched on it, but I want to hear what you have to say, but I'll just briefly emphasize the importance of this fiduciary relationship of the individual that you've selected to have these different powers, and how important it is that you take time and you be thoughtful about who you select, because when they stand in your shoes, they're making some pretty powerful decisions when it comes to your money. Sadly, we both know of situations where people have used powers of attorney for financial powers of attorney to empty bank accounts. We know people who have made health-related decisions for reasons that are more selfish than they are thoughtful about the person that's receiving medical care. So you really have to be thoughtful. If you want to give an example or two of situations that can come up if you're not careful what you do, go ahead.
Yeah, well, Jeff, that's really such a touchstone point that you raise. And I mean, I had 2 conferences today on this exact subject. I had a lady in my office who wanted to name me as her agent. Can I do this stuff? Sure, I'm able to do this stuff. But I told her as clearly as I could, I mean, I know this woman, but I don't know her. I mean, I don't know really the dynamics of her children. She's a second marriage. I don't know how she really interacts with her ex or these other folks that are very important to her. The financial stuff may be a little bit easier to do, write checks, pay bills, get the tax returns filed. But making health decisions for somebody I really don't know, I'm not the right guy. And the closer the person is to the person who is the principal, the person who is giving the agency, you're going to have a better product. The more happy the marriage, the better the spouses are. The happier the relationship is with the kids or the stepkids, the better the product is. I can tell you that my experience, I think, on the health issues, Jeff, are much cleaner than the financial issues, because I have had, not a lot, but you do several hundreds of these, and it's just sort of a statistical thing. A law averages, you do 400, 500, 600 powers of attorney. Every now and then you're going to have one that might be maybe abused a little bit. Is that possible? Yeah, sure, it's possible. But what you're weighing off is the public nature of the Ohio guardianship, the costs, the burdens, the accounting, the fiduciary fees, the legal fees, the court costs. And so you're weighing that off. So
on an ongoing basis, as opposed to
on an ongoing basis, and
one time.
Yeah, and so there's a risk, but people have that risk financially. I mean, lots of people have joint bank accounts with spouses and children and uncles and aunts. Every now and then, you'll see some odd things with that too, but it has to do with the character of the people you're dealing with. And clearly, for my practice, the absolute lion's share of the people that see me for this, and I've had some years where I've done 250 financial powers of attorney. And so you multiply that off by 30, 40 years, I can only think of a couple examples where it sort of backfired on me. For the lion's share of people, they're really a super product. It's private. There's no court supervision or governance of these instruments. People want to see them. Unfortunately, if you had to go to a clinic or a medical center for almost anything, when you do the check-in at one of the hospitals, they're going to say to you, geez, Chris, do you have a living will and a medical directive just in case this minor surgery, which has gone right 10,000 times, if it doesn't go right for you, and we can't talk to you, who's going to make a medical decision if all of a sudden something goes a little haywire? So the hospitals wish to see these. They want to have somebody they can talk to and feel comfortable that that's the person. And the same with the banks and stockbrokers, other financial people, insurance agents. They're comfortable dealing with these documents, so they're used to seeing them. So that's why they are enacted, and that's why so many people are getting those things done. Is they work and they avoid the Ohio guardianship. They have really no shelf life once you sign them up. I mean, if you have one that's 25 years old and you go into the hospital, I mean, they may be a little scant at that, but it's valid. And once you sign them up, you can revoke them. There's no tricks. It's not like it's etched in stone and all of a sudden you've made some sort of commitment that you can't alter, change, or revoke anytime when you want to change it. They're portable. You can take them to Florida and it could actually take them anywhere in the world. They would just need to be translated off, and then have it.
Chris, excuse me. Make sure. I want to make sure. Excuse me. Which of the three documents you've been talking about, the financial power of attorney, the health directive, and the living will, are you
Yes, sir.
saying what you're saying now applies to all three of those?
That's correct, sir.
Okay.
Yeah, I've had many people take living wills, medical directives. They're snowbirds. They're down in Florida. Something happens. They go to a clinic. It's not the exact document that may be produced by a Florida attorney, but these hospitals recognize Ohio products. It'd be just like having an Ohio driver's license or an Ohio marriage under the full faith and credit. These documents port over, and so you get tremendous value, tremendous shelf life out of those three things. And to your point, we should have backups. I do everything I can to have a backup, especially with the older people, for having a husband and wife as the agents for each other. Well, maybe we want a son or a grandson in there to back up. When we have an older couple, there's a greater chance that something could happen to both of them, and we have somebody in there to help them out. Also, we don't need the same person to be the agent for the medical person, for the medical purposes, as for the financial. In other words, certain people have better traits at money and money management, and so we can name somebody to be the financial power of attorney agent. And there may be somebody who's a nurse or has some medical experience or is just better dealing with personal type stuff and not so sharp or interested in the financial area. We have that person be the medical power of attorney and sort of divide it up in a family. That's very common because...
Yeah, please focus on that, if you would, particularly on the financial power of attorney, attorney of the state, of the person, attorney of the finances, attorney, in fact, is what I'm talking about.
Yeah, I mean, certain people obviously have more skills in the accounting finance area, and other people have better skills in dealing with people and personal decisions. And also, it's a lot of work depending on what is going on with somebody. If they have a lot of financial transactions and or a complicated medical situation, this can be a lot of work. especially if somebody has poor health and they're running around to different doctors and this and that. And you see 2 doctors and you got to see 5 specialists, and it just goes on and on. So there can be quite a bit of time and energy in this. And so I often suggest that we split up some of this work if we have people that, can do the job. And so we have different people to act as financial agents, and then we have different people to work with the family members on the medical piece. And that sometimes is a good thing. It also gets different if we're talking about children. Say we have a single person or backups for mom and dad. It also brings more family members into the equation. And sometimes I don't know if hurt feelings is the exact word, but people feel that they're not being included enough, that mom and dad are getting all this care and attention from kid X, and the rest of us don't know what in the heck's going on. And so there is some family harmony that sometimes comes out of having extra people in the mix.
Well, back to my question then, again, because I saw this be a bit of a problem. 2 different scenarios. One where you had a financial power of attorney and you had one person, let's say a sibling of one of the individuals sitting before your desk, asking you to make out these financial powers of attorney. And that sibling, they thought that person should handle financial matters. And on the other hand, there's somebody else here who we'd like to make decisions relative to our children. Now, there are different ways of course, we can address that. But something that might impact, and so I want somebody involved here who's going to be the guardian, guardian person, who's going to be making, not guardian, I don't want to cross the streams here.
Agent.
It's going to be the agent here under the financial power, making certain other types of decisions. How do you handle that when they come to you and they want to use 2 different people? There's pros and cons. We've already addressed that a bit, but go ahead.
I like it, Jeff. I like it if the principal is suggesting this, and first of all, they think it is good. And I like it if we get the right people with the right skill set doing the right jobs. And I like it because we have more than one child in there helping. In this case, we're talking about a husband or wife helping mom and dad. It could be a grandparent or a single parent. And I like that because I think it requires some extra cooperation. I think it shows more than one person involved in the transaction. And again, it can be a lot of work doing this stuff, depending how complicated things are. I mean, you can really spend a lot of time. Think how much time you spend on your finances, and think what happens if your health goes south and all of a sudden you're running around to a lot of different clinics and hospitals and doctors, and you're having trouble getting around and every other thing. And then you have the medicines that go along with these things, and different kinds of equipment, medical equipment. It just goes on and on and on. And so you can spend a lot of time when somebody is on sort of a downslope of health, because often we do see recovery and people bounce back, and maybe they're in some sort of assisted living or whatever, and they come out. But a lot of times they don't, and a lot of times it gets worse. And so it can be a lot of work, especially if we're seeing a lot of dementia and those sort of things now. Those people, that's a wicked disease. Those people do not improve. And so it's a constant stair-stepping down. I mean, I know this from my father-in-law and my mother-in-law and my dad. So I have quite a bit of experience on this on a personal level, and it's a big job. It's actually too big a job for one person, really, in a lot of situations.
Okay. Now, I don't know how much more time you want to spend on this. We have a little less than a half an hour right now. We're going to move on to talking about wills and trust. But But I want to make sure that when we're talking about some mythical family here, and where we started, I made reference to partners, spouses. We haven't used the term same-sex marriage yet. And what constraints, if any, might you want to address at this point relative to the documents we've been talking about? And what the status of the law might be now, as opposed to what it might have been, 10 years ago, relative to these documents, and who can expect to have any issues with individuals who are reviewing these documents, the bankers, individuals that want to see proof that someone has that agency relationship. Can you talk to that, address that issue, and how that might come up, or have the recent changes in both the court-made law and statutory laws aided, or do we still have issues that have to be addressed in this context?
Yeah, Jeff, that's a good question. And I think the law is very clear in Ohio that if someone is clear mentally when they do these documents, in other words, you have to know that you're doing a financial power of attorney, and you need to know kind of how it operates. You have to understand that when you're signing a medical directive, you are giving somebody the power, if you're not mentally clear, to make medical decisions for you. The same with the living will. If the capacity of the principal is clear at the time of the signing, Ohio law is very clear. Ohio law is encouraging people to enter into these lifetime agency relationships, the financial power of attorney, living will, and the medical directive. They want people to be doing these. And I can tell you this, in 35 years plus, I have only had I can count on one hand where I've had maybe a clinic, a bank is more recent, where they would say, would you give us comfort, a little comfort letter like you would at a closing, that Mr. X signed this document, that you prepared it, and he was clear when he signed this. And that, if I think of the hundreds of documents I've prepared, it's only popped up a couple of times. So Ohio wants these documents, and it doesn't, the only thing you need to be is 18 and clear of mind. And it doesn't matter if you're married, it doesn't matter if you're divorced, it doesn't matter if you're living at home and not at home, it doesn't matter race, creed, color, natural origin. No, there's no restrictions as long as you're 18 and you're clear. And it is very powerful, and they work. And the key is on the principal that he or she is making a good pick of the agent. That's the threshold point here, because that person is stepping in the principal's shoes, and these documents are written broadly. They're written broadly so that virtually all financial transactions and all medical transactions are governed by the documents.
Okay, that's very helpful. Now, if you would keep in mind those last questions or principles that you were just discussing in reference to my questions about partner relationships, same-sex marriage relationships, this type of thing, as we move into wills and trust. And should there be any nuances there or differences in what you just said in terms of how things can work across the first three documents we've talked about pretty objectively, in terms of who, if you're of sound mind and over 18 years of age, and the person giving the directives is of sound mind first and foremost. they can be done. But what happens when we move into wills and trusts, and whether there are any differences there? But when we talk about that in the course of the next topic on the agenda, wills and trust, I will say, as we've run into in the past, we've got probably about 20 to 25 minutes here. I'm always being particular about the time. And at the point at which you want to move on to some of the other topics we're going to talk about, you just let me know. Okay?
Sure. Yeah, sure. Okay. Well, here's what we're making a big shift here, because the three things we've talked about, the three agency documents, Jeffrey, when you stop breathing, they stop working. Simple as that. If you're not breathing, they're done. So the moment somebody takes their last breath and they have a financial power of attorney, and that could have been used many times, hundreds of times, a medical directive, a living will, somebody dies, those instruments die. Okay. What happens?
Very important. People think sometimes those powers of attorney still, supersede the death, and they need to know that is not the case. But let's
every
go
month.
on.
Every month, one of my clients goes down to the bank with the power of attorney after mom has died, and the banker says, "Please leave the lobby." Okay, but what happens?
That's not funny, but go ahead.
It's the truth.
Yeah.
Okay, so somebody has passed, and this gets us, and maybe we want to just one step back, Jeff, and talk about a key distinction. We need to flush out just a little bit the distinction between probate property and non-probate property.
Okay.
It's not 8 boxes. It's not, Bill Gates doesn't have 5 boxes. You have 2, I have 2, my wife has 2, your wife has 2 boxes. It's either probate property or it's non-probate property. Let's do non-probate property first. You could have a life insurance with a named beneficiary. Something happens, if I have life insurance and I have my wife as a beneficiary and I die, Annie just calls up the insurance company, fills out a designation form, and a week and a half later she gets a check. A joint account at the bank. If somebody has a joint account at the bank, a person passes, the survivor goes to the bank, can continue to have access to that account. A 401k, an IRA, almost every pension plan will permit the naming of a beneficiary. That has nothing to do with probate. Those benefits will pass over. There could be Social Security benefits that pass by operation of law. You could have an annuity. Ohio now has transfer on death and payable on death registration, where you can have a brokerage account or an investment account that would pass to a named beneficiary. All those items have nothing to do with a will or the probate court. The non-probate designation is a 100% trump over my will. So if my will says I give my life insurance policy to Jeff Swillinger, but my life insurance policy names my wife gets that policy. It doesn't matter if I have it in bold letters and notarized in my will. The non-probate designations always trump the will. So what's in the will? The will's going to be what's ever left. After you look at somebody's assets, cars, boats, real estate, stocks, bonds, pensions, other assets they may own, everything from oil wells to real estate interests. If there's no designation of those assets, then those assets become part of the probate estate. What we're seeing, just as far as sort of numeric evidence, is if you look, you would see maybe 25, 30 years ago, there was more probate property than non-probate property. Well, now people have really made efforts to avoid probate court. They don't want to have privacy. They don't want to have court supervision. They want more streamlined, if you will, efficient, maybe cost effective in a lot of cases, transfer of assets. So routinely, I have people in my office literally every week, and we go through these assets and we talk about what they have and what their plan is and how many of these assets they want sort of to strip out and go directly to beneficiaries. And oftentimes it's either everything or dag near everything that is non-probate. The more complicated somebody's life is, the more active somebody is, the harder it is to get everything non-probate. But if you have somebody who has, say, had a long life, and now they're in, say, maybe an assisted living or there's some other facility, and they sold their cars and sold their house, and they have their assets in maybe one brokerage account and checking account, and they've really sort of downsized where you can really make sure you got all the assets. I mean, I've had great success and others too, where you can almost say, well, there's absolutely no probate property here. Somebody passes, we might deposit the will with the probate court, but all the assets will move out. Now, there's some tricks to that. I mean, if you got 7 kids, you need to be careful that you don't make your beneficiaries 3 or 4 of the kids, and that some of the kids are left off. So when you make these beneficiary designations, and if you have large assets like an annuity or a life insurance policy or investment account, you need to really think it through that the right people and in the right amounts are getting the right assets. So avoiding probate is certainly a goal, but it shouldn't always wag the dog. But conceptually, there's 2 streams. There's the non-probate stream and the probate stream. Okay, so
the important thing, I guess, here at this juncture, what you're saying, is when you're coming in and doing your estate planning, you're going to be talking about your assets with your attorney. And you're going to have to be prepared to explain what assets you have and how they're held in a bank account, in an IRA account, life insurance, and this type of thing. And you're going to be asking, how are they titled, so to speak? How are they in your name? Life insurance, if they name a beneficiary, who is that beneficiary? Is that who you want it to be? And your will and your non-probate assets need to be consistent. Is that a fair statement?
that's a fair statement. And I get it. There are some people who are very private and are sometimes cautious maybe on how they want to disclose their assets. And that's okay too. We can work around this as long as they understand the formula. And the formula being is if they have designated beneficiaries, great. Those assets are going there. And the assets that aren't named, that are, if you will, in their sole name, are going to pass through the probate court. So once the assets are sort of split, if you will, between the 2 paths, non-probate and probate, the probate assets are either going to be governed by the will, and hopefully somebody has a will, because the will allows you to direct how those assets go. And it can be, the only person who has any claim on the estate other than creditors is a spouse. But if we use a single person, which is the easiest example, if a single person dies, there's absolutely no restrictions on what that person can do with their property. They can give it to any charity, they can give it to any person, they can give it to any amounts, dollar amounts, percentage amounts. There's no restrictions whatsoever, as long as there's enough money to pay their taxes and bills. I mean, we've got to have enough money to pay all that stuff. But after that, we have no governmental or statutory rules that say you have to leave a certain amount of your property to your brothers or your sister or your mom or your dad or your children. There's no money or percentage guidelines that are enforced by the government, either on the federal or the state level, on what somebody can do with their assets. So people are totally free. It's unfettered on what they can do. And so they can name and anything that's, well, you can't do illegal acts through a will. But if it's something you could do during your lifetime that's legal, you could do the same transaction through your estate, either to give to charities and individuals in any size, shape, or form. And so having a will is very powerful because you can direct where your property goes. Now, if you don't have a will or there's a defect in your will, Ohio gives you a free will. You get a free will. It's called Ohio Descent and Distribution. And basically it is, if you're married and you don't have children, it goes to your wife. And if your wife is not around or is predeceased, then it goes to your children if you have children or your grandchildren. And if they're don't have any of those folks, then it goes up the tree, if you will, to your mom and dad. They share equally or all to the survivor of them. Then it goes down to your brothers and sisters. And then after that, it goes back through your relatives, your grandparents on your mom and your maternal and your paternal side. And if you have a second or third cousin, there would be a taking by your blood relatives.
Okay.
So you either get a will through the state or you make your own will.
Chris, I want to clarify one point. What's the status of if you have a husband and wife and one of them decides that they don't want to leave under their will what the other one thinks that they should leave, okay? But the first one goes and executes a will, and they die, and they've executed a will leaving out the spouse. What's the status of the concept of taking against the will at this point? Because you talked about the ability to do whatever you want to just about anybody. And
Okay, yes. If we have a couple that are married, and let's say the husband does not wish to give any of his probate property. We're talking about the probate property.
Right.
Whatever property the husband can direct outside the probate court to all the things we talked about. We do not have the augmented estate. Some states do have the augmented estate, where all the assets of the dead person would come into a pool and there would be shares that would come off of that. We do not have that. We have a more, I'm going to say a more traditional or archaic system that goes back hundreds and hundreds of years before really this probate property concept was really more fully developed. But the answer is, let's say we have a husband and wife, and let's say we have a couple of children. Okay, first of all the debts, bills, and taxes would be paid for the person who has died. Then the surviving spouse has a statutory allowance. It's $60,000. They get a piece off the top like a creditor. And then with 2 or more children, the spouse would get 1/3 of the estate, and the other part would be distributed off to the children. So there would be a split.
minor children.
They would get a split. They would get a split of that estate.
Mm-hmm. Okay. But that would only apply if there were minor children, right? As far as the children go. If they're emancipated, would adult children, I'm asking, I'm not telling. Would adult children change that scenario, not only minor children?
Yes.
Okay. All right.
And so what can you do in the will? You can decide where your property's going to go. Okay. And then you can name your fiduciary. That's very important. Otherwise, somebody's going to have to come forward and be the fiduciary. You can make charitable bequests. We talked a little bit about that. If there are minor children, you can suggest to the court through your will that you'd like a certain person to be the guardian of your minor children, because you can leave property to a minor, but our court isn't going to permit a minor to get an inheritance because they're under 18, and so the court's going to set up a guardianship, and so somebody has to administer that guardianship. And so it allows you to name a guardian of that person, and
their estate.
And their estate.
Meaning what they would receive under your will. Both some reference there to who would take care of them if it's not the surviving spouse, and
yes.
And also who would watch over their money until they reach a certain age, right?
Yeah, it's not binding on the court, but it's a suggestion.
Yes.
And it's a very powerful suggestion because you've taken the time in your will to name a guardian. And so my experience has been, I've never seen the court not take the suggestion, but the person would still have to apply to be the guardian and handle that affairs. But that's a very powerful thing. So you have a lot of benefits. Plus you can also waive the bond. The bond in the estate can be expensive depending on the size of the estate and the kind of assets they have. The non-real estate needs to be bonded up, so you got a bond to worry with, and so there's plenty of benefits you get, and the drafting of a, if you will, a simple will. This is not the IBM antitrust case. It's a relatively simpler procedure for attorneys drafting up a simple will and waiving the bond and naming a fiduciary and naming some beneficiaries and talking about some guardians for children. This is something that the bar handles effortlessly
Okay.
and efficiently.
Now, I'm going to interrupt you. As we've run into in the past, we have more to talk about than we have time. And they're telling me that I've got about 4 minutes remaining. How we jumped from 20 to 10 to 4, just a lot of discussion, a lot of substance here coming from you, and I appreciate it very much. In the 4 minutes that we have remaining, looking at this nice outline that you gave me for us to follow a bit here, what might you want to talk about now so we can fit that in? Or I could try and twist your arm, maybe try and have you back in a month or two and do part 2 of this.
I'll give you 2 quick pointers. Okay. And you kind of mentioned it, Jeff, at the very top end when we talked about a family, a mom and dad, maybe a couple young kids. Anybody who has minor children should really think about a minor child's trust. It's a backup trust. Something happens to mom and dad. It'd be set up for the kids. You can have it run through college and out a couple years. It avoids Ohio guardianship law for minors. They're very effective. They're very cheap. They work. And I think most people would agree somebody that's 18 years old should probably not inherit a lot of money. They may not make super sound decisions. The other thing I would say, this is not a tax show, but I've done a lot of tax shows in the past. And like the worst thing you can do is not file your tax return. Don't worry about paying it. Get the return filed, because the most significant penalties are failure to file. The failure to pay is like 10% of the failure to file. So you can end up paying more than 50% in penalties just by not filing your return. IRS will send you a bill for the money you owe, but they will not penalize you the failure to file penalty as long as you file your tax return by the due date.
Okay. Very, very important. Go back, if you would, to the estate tax. People wonder what estate taxes are going to be due when someone passes away. Just briefly, federal, state of Ohio taxes, what taxes, if any, are there?
Okay, no problem. We live in a very tax-free area now. Ohio repealed 100% its Ohio death inheritance tax in 2013. The tax crudely was a sales tax for a single person, was 7% over approximately $300,000. So anybody who's single that has a net estate greater than $300,000, there's no tax now for that person or any other person. Bill Gates could move to Ohio and die and owe Ohio no death tax. The federal death tax this year has been increased through the inflation adjustment. It's now just a notch over 12 million per person, 12 million. So really in the last 15 years plus, it's been increased from 1 million to 12 million. And so a married couple, they can port back and forth their exemption. So a spousal couple can have 24 million before there's $1 of death tax. So this is a very pro taxpayer scenario for Ohio and federal death tax.
Excellent. And as we go out the chute here, that's very, very important. And I want to emphasize the fact that these are not the kinds of issues that people should be handling on their own, and they should be seeking out professional advice from professionals who specialize in this type of work, such as yourself, or individuals that they might contact through the Dayton Bar Association or a referral service, or through referrals from trusted friends and family members, I would I would hope. Chris, thank you very much for being here. It's always a pleasure, and we always have a lot more to talk about than we have time. My thanks to the staff also of DATV. As I said previously, they do a wonderful job in bringing this show live to the community. I think we're about done for the evening. Chris, take care. My best to your family, and we'll be talking soon, I'm sure.
Thank you, Jeffrey. Great seeing you.
Great to see you too, my friend.